British nationality law is highly complex due to a number of different factors, but in particular the number of changes that have been made in this area of the law, particularly during the decline of the former British Empire and since the introduction of the British Nationality Act 1981. Another important reason is that many of the provisions that were previously contained in nationality law are what we would now understand to be discriminatory. So for example, previous nationality law didn't always treat men and women equally within the law. As a result of corrections made to the law since then, there are now over a dozen application forms that can be used to register as a British citizen, depending on the particular background circumstances of the application. Over the last 20 years, a number of amendments have already been made to British nationality law in an effort to correct historical injustices that were previously contained in previous versions of the law. However, perhaps recognising that no matter how many amendments were made, they would probably not cover all people who were previously impacted. Last year in the Nationality and Borders Act 2022, a new section, Section 4L, was introduced into the British Nationality Act 1981. This new section states that a person of full age, i.e. over the age of 18, and capacity may be registered as a British citizen if, in the opinion of the Secretary of State, they would have been or would have been able to become a British citizen but for one of the following: historical legislative unfairness, an act or omission of a public authority, and then the rather generic exceptional circumstances relating to that person. The Home Office have published guidance on what might constitute historical legislative unfairness. Generally speaking, it involves discrimination based upon a protected characteristic. And they've also provided some useful case studies as well for their caseworkers, setting out when an applicant may or may not be eligible to register under this new section. However, the guidance pertaining to this new section of the law is still relatively light and is likely to be expanded significantly over the coming years. So it's strongly recommended that you obtain legal advice before making an application. The advantages of being able to register as British are numerous, and they will differ depending on the circumstances of the applicant. However, they may include a greater sense of belonging and identity once they're able to register. They will be free of immigration control in the UK. They'll have visa-free travel to a number of different countries around the world. And also, if the applicant already has leave to remain in the UK, it may be significantly quicker and more cost-effective if they are able to register, rather than having to make multiple immigration applications before applying to naturalise. Due to the complexity in this area of the law, the first obstacle that many people have is that they either don't know that they're British already or have the eligibility to register as British. This is especially true as many claims either arise out of family circumstances that go back many decades, or because of links to countries that were previously part of the British Empire. Linked to this is the fact that it then makes it quite difficult in many circumstances to provide the relevant documentary evidence. This might be because the applicant doesn't know which documents are required, or the required documents may go back many decades and be difficult to obtain. We provide advice in 3 distinct stages. Our first stage is the initial consultation, which is free and typically lasts for around 30 minutes. At this stage, it's a really good opportunity for you to outline your inquiry to us, and also for us to ask any follow-up questions that we think may be relevant to your inquiry. Our second stage is the advice stage, which typically costs £300, inclusive of VAT where applicable. At this stage, we will provide you with an advice letter, and where applicable, we'd also provide you with a nationality report detailing your eligibility and a list of documents required to support the application too. Our third and final stage is the application stage. At this stage, we would review any supporting documents that you provided to us. We would also assist you with drafting and submitting the Home Office application form. We would book a biometrics appointment for you once the form was submitted. We would upload all of your supporting evidence ahead of the appointment, and we'd also draft a detailed cover letter in support of the application too, tailored to your circumstances and setting out why you meet each of the requirements. Here at OTB Legal, we are a solicitor firm regulated by the SRA. We have an expert team that will be able to guide you through the application process from start to finish. We also make use of technology. We use an advanced software tool called the AORA nationality determiner, in which British nationality law has been codified to help us assist with your inquiry. Our prices are transparent and we use a highly competitive fixed fee structure. So if you are looking for assistance with your British nationality application, we'd love to hear from you.